Hello, and welcome back to Part 3, Chapter 7, Consideration and Form, Section G, Nominal Consideration. This section refers to consideration of insignificant value. It offers benefits that is not even close to the real value of the agreement. An example would be $1 offered in exchange to create a binding contract. In the case Thomas versus Thomas, the deceased Thomas executor made an agreement with his wife. Okay. The agreement was that the wife is to make an annual contribution of £1 per year in exchange for the benefit of occupying the premises during her lifetime or until she remarried. The court viewed that the agreement constituted a good consideration. A Canadian case where the court did not give effect to the transaction involving a nominal consideration is the case Harding versus Harding. In this case, the husband bought his wife's interest in a matrimonial home for $1. This failed because it lacked mutuality. This type of agreement is very oppressive. The husband took advantage of the wife's desperation to return to the matrimonial home and reunite with her husband. It would be wrong for the husband to request the wife to release interest in the matrimonial home in exchange to return to the matrimonial home. The court would not enforce this type of agreement. In the case Gilchrist Vending Limited versus Sedley Hotel Limited, the hotel granted Gilchrist an exclusive right to have their vending machine installed in the hotel. The contract also permitted Gilchrist to terminate the agreement on the payment of $1. The court was consistent with a well-established principle, quote, to the effect that anything of value, however small, is sufficient consideration to support a contract, unquote, page 225. In this case, the Court of Appeal allowed the firm to offer purchase interest in exchange for $1. An example of a nominal consideration mechanics provide would be the promise to pay $1 in exchange for the promise to pay a large sum, let's say $1,000, for example. This would not be considered a bargain. Rather, it would be considered a bare gift. Under this theory, the popcorn theory would be restricted to the case where something of value, unknown value, is being exchanged for $1. Alright, in the case Mountford versus Scott, a decision was ruled that the possible future obligation could be avoided by the payment of $1 were illusory. Alright, Section H, Forbearance. The promise given in return for an actual conduct of forbearance is enforceable. In the case RBC versus Kisha, there was a guarantee for the promise to repay the loan. The promise to forbear can be a type of consideration in the context of compromise of dispute. An example of forbearance is an employer's promise not to terminate an employee for a reasonable period of time in return for the employee's agreement to new terms. In BDC versus Arkins, forbearance to sue is considered is a valid consideration, subject to certain condition. Money is paid in exchange for a promise not to sue is a valid unenforceable contract. The forbearance can be good consideration even if the validity of the claim is doubtful. Alright, in the case Stott versus Merit Investment Corp., Stott's client failed to pay a debt. Stott's supervisor got involved and granted the client new financing. After this event, Stott was persuaded into signing an agreement that released him from being responsible for paying the debt. There was an implicit agreement that Merit Investment would forbear to fire or sue Stott. The Court of Appeal held that an employer's promise not to sue an employee who was indebted to the companies for losses coming from his client's financial obligation will constitute good consideration. Thus, the promise to forbear can be good consideration. The importance of this case was the status of the claim, a bona fide claim, at the time of the assertion. The court determined that the employer had a legitimate cause of action against the employee. Alright, so let's say in B, DC versus Zellers, the claim asserted against the parents was invalid. The parents cannot be responsible for the tort committed by their children. Page 228. Parents can be liable if, I quote, if they had committed a tort such as negligent supervision of the activities of their children, unquote. Okay. The parents of these thieves received a letter from Zeller's lawyer threatening to pursue the purported civil claim, unless the parents were willing to settle this out of court by paying this settlement fee. Okay. Page 228. The court ruled that the promise made by Zeller to forbear from suit is not a valid consideration. Section I. Charitable subscription. Promise to make a gift is not enforceable for the want of consideration. Promise to make gifts to charity will have a subtle consideration. In the case Governor of Dalhousie College at Halifax versus the estate of Arthur Voltaire, Arthur promised to pay the college a large sum of money. Arthur wasn't able to fulfill his obligation due to financial difficulties. However, he wrote a letter to the college explaining that he would fulfill his promise. When Arthur had passed away without paying the college sued the estate with the argument that they had acted in reliance of the money. The court rejected the claim because the college had no consideration for Voltaire's subscription. There was no reliance or valid consideration, no exchange or bargain. Thus, the contract is unenforceable. Other cases suggested that the subscription is revocable to the point at which the charity relies on the subscription or incurs obligation. Section J. Manufacturer's warranty. The distribution or retailer passes the product from the manufacturer to the buyer, where the immediate party is not acting as the agent of the manufacturer. The manufacturer's warranty is not binding. A few Canadian provinces have enacted a law that imposed some form of liability to the manufacturers. There could be a binding contract if there was a direct communication between the buyer and the manufacturer. If the purchaser purchases the product from a dealer, the manufacturer is bound to the warranty. A common assertion is to have the consumer to send a postcard with the registration information to the manufacturer. By doing so, the product's warranty will be registered. McCamus states that the information given to the manufacturer will constitute a valid consideration. Alright, so let's look into past consideration, part 2. Past consideration is an act which has been performed. You will not be able to bargain for something that has happened or has already taken place. Past consideration is not enforceable. A promise given today in exchange for a benefit received in the past is not going to be enforceable. There was no effect to consideration. If consideration for a promise was given in the past and executed long ago, the promise is not enforceable. In the case Eastwood versus Kenyon, a husband promised to discharge a debt owed by his wife's guardian to a third party. His wife's guardian borrowed money in order to provide his wife with an education. This all happened in the past. Quote, consideration for it was passed and executed long before. Page 232. Past consideration may provide the promiser with a motive for a fresh promise, but not consideration. If there is no consideration, it is unenforceable. Alright, so that is the end of part 2. We'll look at part 3 of chapter 7, consideration and form. So until next time, we'll see you then. Thank you very much, and good night.